if we were to follow Mr. Lott's theory of that, then an attorney could tell his client, you can commit murder.
Is he willing to return the child anytime soon, or what is his plans?
Like what month, what day, what year?
You never returned the child for a year now?
And on that date, were you called out to help with a child custody case?
Yes, ma'am.
Where were you called out?
Sorry, I don't recall the exact address.
Would it be helpful to review your report and refreshing your memory?
That would be great.
Okay, so where were you called out to?
It was 8139 Ellerston Boulevard.
And is that in Bear County, Texas?
Yes, ma'am, it is.
And when you arrived at that location, did you make contact with anyone?
Yes, ma'am.
Who did you make contact with?
I'll mispronounce it. Sharia Golden Lee.
And did you speak with her?
Yes, ma'am, I did.
And what else did you do when you arrived at that house?
She explained to me the troubles that she was having in regards to child custody. She asked me to try to retrieve her child from the 8139 Ellerston.
And approximately what time did you arrive at this address?
I was dispatched at 5:41. I would have responded probably about between 5 and 10 minutes from that time.
You say 5:41, was that 5:45 in the morning or 5:41 in the evening?
5:41 in the morning.
And did you attempt to retrieve Omari Toussaint for Ms. Charita Golden Lee?
Yes, ma'am, I did.
Okay, and how'd you go about doing that?
I responded to home, knocking on the front door, ringing the doorbell. There was no response.
Do you remember anything about the doorbell or the front door?
Yes, ma'am. It was equipped with a video doorbell, so even if the homeowner wasn't home, it would have gone to their cell phone and they would have been able to speak with me.
And were you able to make contact with anyone?
No, ma'am, there was no response.
Were there any cars in the driveway on this day?
Yes, ma'am.
What kind of car was in the driveway?
It was a black SUV, and I wrote down the license plate as 63DB71.
Were you able to ascertain who that vehicle belonged to?
Yes, ma'am. I did a registration check on it. The registration came back to Mr. Toussaint.
Were you able to retrieve the child Omari Toussaint for Ms. Charita Golden Lee that day?
No, ma'am, I was not.
Did you have any other involvement in the case?
After I tried to make contact with the house, I went back and I talked to Ms. Golden Lee. She was explaining the troubles that
Objection,
she was.
hearsay on.
Sustained.
Did you go back to the house at all?
No, ma'am. I believe that was the only time I responded to the house.
The address that you were dispatched to, do you remember?
I don't remember the exact one. Check. Yeah. Looks like 8139 Elsinburg Boulevard.
Okay, is that located here in Bear County, Texas?
Yes.
So when you're dispatched, did you actually make contact with anybody out in the field?
Negative.
Okay. And when you were dispatched to that address, did you talk to any witnesses? Did you attempt to make contact with anybody?
We attempted to make contact with the father of the child, but nobody was available.
Okay. And when you mean nobody was available, What do you mean particularly about that?
Nobody answered the door.
So you or somebody else you were with knocked on the door?
Correct.
So after you're done from that address in Selma, you go back to the police department?
That's correct.
Once you're at the police department, do you talk with any witness?
We attempted to make contact with the father of the child, to see if there's some kind of once he gets out of the story and to try to figure it out.
And did anybody contact you on his behalf?
That's correct.
Who did?
It was an attorney representing the father of the child.
Prior to that, did you reach out to Mr. Toussaint's attorney or know who his attorney was?
Negative, I didn't know who it was.
Okay. Do you know how he got information to contact the Selma Police Department?
Not exactly. We did leave a voicemail for the father to contact us to try to get his side of the story.
So eventually that attorney called you and were you able to speak with the attorney?
That is correct.
And after speaking with the attorney, what did you do next?
Based on the evidence that we had at hand, the lack of communication with the father, we filed the case as an interfering with child custody.
Tell us what Otis had told you in relation to why things might have changed or going to be changed.
Yes, he asked me for an extended visitation with Omari because he had cancer and he wasn't sure what the prognosis was going to be.
Based on him telling you that,
Mhm.
and based on your interest in your child, love of your child, did you agree to that?
Yes, after speaking to Omari, I asked him how he felt about it, and he said, okay, but I want to make sure.
Objection, Your Honor, hearsay. That will be sustained.
And you could tell us what, not necessarily what somebody said. I'll ask you specifically when I ask you what somebody might have said, okay? But you are saying that you had considered it and in consideration you had agreed to it, right? What was your understanding of how long this temporary possession was supposed to be?
He was supposed to finish the 3rd grade school year, so school had already started. He asked to have more visitation with him, and we discussed Omari coming to finish the 3rd grade school year with him in Germany. Yes,
And so that was in June.
yes. And at one point, I would have, like, we wanted
Objection,
to.
not responsive. Sustained.
So were you aware at that point that he was going to petition to have them changed in a court?
No,
And this agreement that you reached with him for this temporary, basically extended visitation, was that in writing with him? Was that verbal? How did you make that arrangement with him?
it was verbal first, and then he mentioned something about us putting it in writing.
Eventually, was it put into writing?
Not to my knowledge.
So I'm going to show you what's been admitted as State's Exhibit number 2. So in your dealings with Mr. Toussaint and subsequently, did you come to find out about the existence of this order?
Yes, I did.
Okay, and how did you find about the existence of this order?
I found out about this one in particular from the principal at the school.
Right, if it's not the contents of the statement. then that'll be overruled. But if she's going to be speaking about what was said, then that will be sustained.
I understand.
Judge, and I would also object to the leading nature and speaking objections of counsel to say what an answer would have been coming from the witness when she has an answer.
I'm talking about what's on the record.
All right, so ask your question, please.
Thank you, Judge. So the principal called you. And did you respond to that call? And I'm not talking about the conversation. Did you do something in response to that call?
Yes,
What did you do?
I went to the school
What was your purpose of going to the school?
to see why he was there, because the principal probably said that he was there.
He being Otis.
Yes,
And when Otis came to the school, without saying what somebody told you, did you come to learn what he was there for?
yes,
What was he there to do
to remove Omari.
from the school?
Yes,
And was he successful in taking Omari from the school?
yes.
Do you remember what date that was?
October the 15th of 2018.
So October 15th of 2018, Otis takes Omari from the school. And I was in Memphis, Tennessee.
Yes.
And at that point, was Otis residing in Memphis?
No, he's never resided in it.
So after you said it was October 15th of 2018? When is the next time you had possession, physical possession of Omari?
That was March of 2020.
So from October 15th of 2018 up until March of 2020, you never had physical possession of Omari.
No, I did not.
And during that period of time, what's been admitted as State Exhibit number 2, which is on the screen, the order from Clarksville, Tennessee, was that appealed and vacated by by the Tennessee Court of Appeals.
Yes.
And do you remember when that happened?
I got that response from the Missouri Court of Appeals in October of 2019.
So I'm going to show you what's been admitted already, the State Exhibit number 3. And it's fair to say that that shows that it was, the notice filed date was October 10th of 2019.
That's correct.
So even after October 10th of 2019, up until March of 2020, you hadn't seen Omari.
No, I had not.
So after this Tennessee order was vacated, you still didn't get to see Omari.
No, I did not.
And you didn't have possession of Omari.
No, I did not.
Do you know if he was in possession of Omari's passport?
Not at the time. I had Omari's passport.
Did you give Mr. Toussaint Omari's passport?
I did not.
But subsequent to that, Omari was taken out of this country,
Yes.
despite you not giving Mr. Toussaint or anybody Omari's passport.
That's correct.
As far as Facebook is concerned, were you previously friends with Otis Toussaint on Facebook?
Yes, I was.
And do you remember about what year you would have been friends with him on Facebook?
That was back in 2006, my freshman year of college. That's when we met and added each other as friends on Facebook, and so
Okay.
2006.
So from 2006 up until, I want to say, let's talk about October 15th, just say October of 2018. Did you know Otis Toussaint to have that same Facebook profile?
Yes,
And where did you have access to it? Meaning, could you view his profile?
yes,
In particular, in reviewing his Facebook, which you had access to, did you come to find out how I'm sorry, Omari was able to leave the country despite you not giving a passport to Mr. Toussaint or anyone else.
Yes,
Your Honor, may I approach?
Yes.
If you can, go ahead and read what's on this screen for me.
it says, let me minimally detail the past 36 hours. Super tired and adventurous journey because his passport is lost. Okay, challenge accepted. 3 hours drive at 3 AM to Clarksville to get judge's permission to get passport solo. 3 hours back to Memphis to get things.
Then continuing on,
Six,
I'll move on to the next one. Continues. States exhibit number 8.
6 hours drive at midnight to Atlanta to the passport agency for an 8 AM appointment, forgetting that I jumped 1 hour at a time, knowing I could potentially be denied while anticipating a 3 PM flight to Germany. Make the 8 AM appointment, 12 PM passport confirmation, 12 hours flying back to Germany.
Continuation of that, that's the bottom, and the middle of states exhibit number 9.
2 hours, 12 hours flying back to Germany and 2 hours drive back home.
Okay, and then you can see this picture right here where my finger is, has some yellow in it.
Yes,
That further blown up in states exhibit number 10. Is that the same photo?
yes, this is the same photo.
In particular, it looks like something is circled on that picture. And what's that circle?
It says primary evidence of sole authority to apply, such as a court order, or
Did you get permission for Omar to get a passport?
I did not.
On October 15th, 2018, were you aware that Otis Toussaint was taking your child to Germany?
I was not.
In written or verbal, did you get permission for Mr. Toussaint to take your child away from October 15th of 2018 to March 2020?
I did not.
Say what's been admitted in states exhibit number 1. Particularly, this is relating to the custody order from 2011 in Missouri. It says in number 2, ordered that the parties will have joint legal and joint physical custody of the minor child, correct?
Yes,
So from October 15th, 2018 to March of 2020, did you have joint physical custody of Omar?
I did not. It's been so many documents. I don't remember the exact details of the letter, but I think from my memory, it was some type of notice about him being here in Texas. Texas was my original order.
Your original order date of 2011.
Yes,
When Omari was in Germany and subsequent to that here in Bear County, were you able to communicate with him?
no.
Did you ever get to talk with him on the phone?
Oh, it would be situations where, like,
And just answer this first question.
yes,
Did you ever get to talk with him on the phone?
yes, but
And
minimal, very minimal.
how would you get to talk to him on the phone?
Omari would call me and he would say hi and he would hang up. It wouldn't, there was no conversation about what was going on or any of that. It was like, hi. And I'm like, hi, son, how are you? And then he'll say he's fine.
Objection, non-responsive.
And then
Sustain.
And when you were able to speak with him on the phone, was that because you called him or he called you?
No, it was because he called me.
And did you try calling Omari and Mr. Toussaint during this period of time between October 15th of 2018 and March of 2020?
Yes,
And were you successful in reaching him?
No, I was blocked.
So when you tried to call him, the number would come back that you couldn't even call.
Yes, that's correct.
There wasn't ever another order entered.
No, it's,
Okay, so
you
then
said
what was-
another order, what do you mean, what order?
I mean, an agreed parenting plan and an order that designated that Omari would be going to Germany with his dad, and that the split would now be 200+ days and 80
No,
days.
no.
So then, ma'am, what was vacated by the opinion in 2019?
Okay, I can explain it to you.
Well, which order was it?
It was the conjured up Clarksville order that he had. I never agreed to that. That was something that he did when he was in Clarksville. By the time
Ma'am,
I
sorry,
saw,
object is still
I'm trying to
responsive.
answer the question.
Overruled, you can answer the question.
Thank you. At the time that I saw that, I had no knowledge of Otis doing anything in Clarksville. I had not been to Clarksville. We did not have a court date. It was not anything on the record. I had never set foot in Clarksville. The time that I went to Clarksville was to ask for whatever he had to be set aside because we were already having litigation in Tennessee. And they told me in order for it to be sorted out, whose is right and whose is wrong, I would have to go through the Court of Appeals. So the Court of Appeals job was to look at my original order from 2011 and look at what he had from Clarksville from whenever. And they decided that the 2011 order was the status quo. And they dismissed whatever it was that he had because it wasn't
Objection.
on the
Your Honor.
record.
I'm sorry. All right, ask your question.
Did you not say earlier that Mr. Toussaint went to the school to get Amari and he had a court order?
Yes, but the court order that he had didn't have any signatures on it. It was a blank order, and the only thing that was on it was my signature. And the way that I know that is because the principal printed it off and he gave me a copy. It did not have Otis's signature on it. It did not have a state seal on it. It didn't have any fixings that tied it to be a regular court order between two people. So that's what he showed up at the school with the first time he tried to take Omari. That was the first time.
Ma'am, were you ever instructed by a court after Amari came back from Germany? Were you ever instructed by a court to return the child to Mr. Toussaint?
I was not.
So is it your testimony that at no time were you ever held in contempt by that same court?
I was not.
So then in the opinion, when it says they vacate the order and there's an issue with the effectiveness of the order, just the date, what are they referring to? When they say, let me finish, please. When the opinion says in reference to Mr. Toussaint's contempt action, what are they referring to?
They are referring to his Clarksville order. They're not referring to me. I'm the one that went to the Court of Appeals, not Otis. They're referring to what he has. And that's why we are back to the Missouri order as being the status quo, because what he had was set aside, not what I have.
The Court of Appeals set it aside, correct?
Yes.
But the judge at the trial court level, he ordered you to turn over the child, did he
He
not?
did not. He did not. He did
In
not.
fact, he also ordered you to turn over the passport
He
of the
did
child,
not.
correct?
No, ma'am.
And you did not do that, did you?
He did not order me to do that.
And it's true, is it not, that because you failed to do that, that is why Mr. Toussaint was allowed to get a second passport under emergency
That is
circumstances?
incorrect.
So I'm going to talk to you about State's Exhibit 3, which has already been admitted, okay?
Return the child's mom or go back to Missouri, which they could have done.
So did Otis ever ask you, did he ever say, Mr. Rodriguez, what should I do here? Did he ever ask you about giving the child back to mom? Did he ever ask you about that?
Yes,
Okay. And specifically, did you get a call? Every lawyer loves this. Did you get a call in the middle of the night asking you this question?
yes.
Okay. And where were you in the middle of the night?
It was around New Year's. We had gone to, my wife and I took our two kids to Ritos, New Mexico it was our anniversary. It was our anniversary on January 3rd. So we went, I believe, New Year's Day. So we were on vacation at the time.
So you're on vacation in Ruidoso, And Otis gives you a call, is that right?
Yes,
Okay, Otis calls you and he says, the police are at my door, what do I do?
yes,
Something like that, right?
yes,
Okay. And did you give him legal advice?
yes, I did.
Okay. What was your legal advice?
Your Honor, at this point, I'm going to object to your saying.
Sustained,
Judge, he is testifying about what he said.
sustained,
Can I approach her?
for what purpose?
For explaining,
No, the objection has been sustained.
so you did give him legal advice, correct?
Yes,
And did you tell him to give the children back, or
Your
the child
Honor,
back?
I'm going to object. This answer calls for your saying.
Sustained,
Did you call the police that night yourself?
I believe there's some calls back and forth from, sir, actually, I did, I called them.
Okay. And did you explain to them why it was your opinion that Otis should not give the child back?
Yes, I called and explained to them because at the time they only had Sharita's side of the story, so I wanted to make sure that they had a full picture of what was going on. It was much more complicated than simply waiting a court order. There's several states at play at that point, there were several orders at play. And so I was trying to explain the entire, the state of things at that point.
So are you familiar with a list of acronyms, the UCCJEA?
Yes,
Are you familiar with that? Okay. Can you tell the jury, what is the UCCJEA?
the UCCJEA is the Uniform Child Custody and Enforcement Act. And so that's an act that all the states are part of so that there's uniform rules regarding jurisdictional issues.
You would agree that in filings in cases that you have represented Mr. Toussaint on, you have stated that the Missouri order is the controlling order, correct?
Yes, it's the order that we're seeking to modify.
That's not my question. My question to you is, in your filings, in your representation of Mr. Toussaint, you have in writing to the court have stated that the Missouri order is the controlling order, correct?
Yes, that's the controlling order that we're seeking to modify, but not saying that that's the controlling order that controls the possession access.
But there was a child custody agreement that was acknowledged by him that she provided. Based off of that, we contacted the DA in Bear County. And they said to go ahead and follow charges based off that decree. So we're gonna follow charges with interfering with child custody. It's scanned into the report. So
So basically what's going on is, they had some order way back, I think in 2010 back in Missouri, they had some other order in
Tennessee.
Tennessee, and then we have a case pending in Bear County. Basically, right now, this is going on in Tennessee and in Texas. And I just want to know what order that's going off of that she's giving you, so that I can point that in the right direction, because, yeah, even if it's going off some order that they had from Missouri, if you read the order itself, which again, that's not even, I don't know what state this case is in, because there's been appeals and back and forth. Basically, even if you don't look at that Missouri order and read the language, today is his time. Like, he gets New Year's right now, so it's not, you guys are violating the order.
So what year does she get it?
Okay, so the way, I know it's very different from Texas, but the thing is that we have to follow what the judge says. So if it says New Year's Eve, that's fine. But the thing is that today's New Year's Day, I didn't see that on there. So is he willing to return the child anytime soon, or what is his plans?
Like what month, what day, what year?
Because she's saying that he has never returned the child for a year now, and let's just say that has happened, that's fine, okay. But our main concern is to get the child back to the person that he's supposed to be with. So is he supposed to give the child back today or tomorrow? Is that his plan, or is he just gonna keep the child until the court finds out what they want to do?
Pending the court order there in Tennessee. So basically, this case is going on in Tennessee. This order that he's talking about is Missouri order.
Right, but so this is the thing, who's supposed to have the child during that time?
Hey, Mr. Rodriguez, during that phone conversation, you would agree with me that multiple times you tell him, them, both of the officers on the other line of the phone, that how can he violate the order, right? And the order you're referring to is the 2011 Missouri order.
How can you violate the order?
Right, you said that multiple times, correct?
Yes.
And in that, you even talk about specific dates in that order and specific provisions in that order, especially as it relates to New Year's Day, correct, and New Year's Eve.
Yeah, so I was trying to, well, one, listening to it again, I realized that they kept cutting me off, they didn't let me explain that that wasn't the court order, but I told them, even if, which is saying that's not what I believe is the controlling order, even if it's the order that you're relying on, the only half of the story that she provided, then even then, he wouldn't be violating the order.
Did you ever use the word status quo during that conversation with them?
I'm not sure, a lot of it was cut off.
Okay. And
That's not controlling, but I know I'm trying to explain that it wasn't controlling.
so when you listened to it just now, that was the second time you've listened to it, right?
Yes.
So you still don't know if you didn't tell them that the 2011 Missouri order was not controlled?
I don't think I told them that specifically. What I told them, what I was trying to explain to them was that it wasn't the controlling order.
If when you're talking with the officer in this case, they ask you, well, when is mom going to have possession of the child? And they ask you specifically day, month, or year, right? You remember that question?
Yes.
And you didn't provide an answer to that question, right?
There's not an answer. That's what we're trying to figure out. We're trying to get an order in place so that we know those answers. And so at that point, there wasn't an answer. That's what we're trying to figure out.
So it's your legal opinion that Mr. Toussaint can have this child from October 15th of 2018 until March of 2020. And that would be compatible with the current order that's in place.
How long have they been sitting there, Jen?
Since the break, I brought them back for you.
I didn't even see him.
All right, so we're outside the presence of the jury, and it's with regards to the jury charge. They're bringing a draft of the jury charge out to you, and I'll have you all look those over. And by my understanding, Mr. Locke, you're going to want what in the jury charge?
A mistake of law and a mistake of fact.
And State, are you ready to argue that point, or do you need a moment?
I believe that I'm ready at this time.
Okay, all right, the court will hear your argument.
So as it relates to the mistake of law first, the penal code under section 8 says that first of all, that it is not a defense. The only way that it can be a defense is that it is in a essentially in a court order, or it is a opinion issued by an authority with the I don't want to say authority also, but with the obligation of interpreting that. I think most of us would think that as a attorney general, and so that affirmative defense doesn't apply here in that this is a court order, not a published opinion relating to the analysis and enforceability or opinion as it relates to the law. And so he was not relying on an interpretation of the law by a court in committing this act. And so I think it's proper to give that to the jury.
Those questions are ripe for both a mistake of fact and a mistake of law defense. So let's look at 8.03(b)(2) of the Texas Penal Code. It is an affirmative defense, prosecution, that the actor reasonably believed the conduct charged did not constitute a crime and that he acted in reasonable reliance upon a written interpretation, and then I'm going to subsection 2, okay? A written interpretation of the law contained in an opinion of a court or made by a public official charged by law with responsibility for interpreting the law in question. Okay, so Has the court heard a scintilla of evidence about that? And absolutely, Your Honor, you've heard tons of evidence about that. You have heard that we're interpreting the Tennessee order, that we had an attorney, somebody who's charged by law with the responsibility for interpreting a law in question. He's interpreting that order, applying it to Mr. Toussaint's case, telling Mr. Toussaint, maintain the status quo. Mr. Toussaint follows that advice. And as he's following that advice, he's then charged with a crime. This is a mistake of law. It is absolutely textbook mistake of law defense.
So you're saying that the attorney who testified, Mr. Rodriguez, stated that he informed him that he was not to give custody
To maintain the status quo. And that the status quo was that Otis had custody of Omari.
So you're saying that
And that
the
relying
witness
upon
who
that-
testified, you're saying that the witness, the attorney who just testified, he testified that he informed the defendant that he was to maintain the status quo, and the status quo was
that he had
not
custody of-
giving
Yes,
visitation to the complainant?
yes,
Okay, I just wanted to be clear.
yes.
And Your Honor, if you look specifically at the mistake of law as it relates to B2, it's a written interpretation of the law, not an order, but the law contained in an opinion of a court of record, right? Or made by a public official charged by law with responsibility for interpreting the law in question. It doesn't apply in this case. We have an attorney who is not a public official charged by law with responsibility for interpreting the law. And he is neither an opinion of a court of record. So it's completely inapplicable.
And that is a complete misreading of that statute. A written interpretation of the law contained in an opinion of a court of record. Okay, the Tennessee Court of Appeals is a court of record. That is a court of record. I don't think there can be any dispute. Okay, made by a public official charged by law with the responsibility for interpreting the law. Okay, public officials, attorneys are public officials. We're members of the state bar, we're officers of the court. We're charged by law with interpreting opinions and giving that opinion to our clients who can then rely upon it. Yes, it is within the four corners of this, and we've heard far more than necessary to get an affirmative defense on that.
And Judge, if we're going to follow Mr. Lott's theory of that, then an attorney could tell his client, you can commit murder, and then it would be a mistake of law defense.
And Judge, that would be true if we had a court of opinion, a court of appeals opinion saying this person can be murdered.
All right, and what's the, so I've heard all the argument on the mistake of law. You want to proceed now with your argument for mistake of fact?
The mistake of fact is what valid order is in place.
State.
Mistake of fact would be like, I didn't know an order existed, right? Mistake of fact is that there's some fact not within his knowledge that he relied upon. This is an interpretation of a fact, right? So he has all the facts in front of him. It's not that he was without a fact to act, right? And so how I understand and read 802, it's inapplicable in this case as it relates to the testimony that was elicited.